Hari, the regular, says I'm on EB3. My priority date is October 19th, but August Visa Bulletin filing date seems April 20th. Can I file I-485? No, if your priority date is October 19th and the current one is April 2020. No, for EB3 category. Okay, so this is an important question actually. There's one Visa Bulletin chart that comes up every month from the Department of State. And that chart, within it has a subcharts for family-based cases, employment-based cases, and the diversity visa lottery. We're gonna just talk about the employment-based right now. And here is an EB3, the third preference category within the employment-based cases. Now, within those chart sections, there's two charts. There's a date of filing and a final action date. The final action date is the date that the actual green card can be approved and issued. The date of filing is something that President Obama started that allowed people to submit the paperwork sooner to get it started. So that date is always ahead. Now, that's exciting because it means you can start the process sooner, which means you could also file for a work permit EAD or advanced parole if you're in the United States, or just send a document so it's up and running faster. However, once Department of State did that, USCIS came back and said, wait a minute, we're not gonna fully accept that. So every month, when the Visa Bulletin comes out, we're gonna have our own charts come out. Well, it's not their own charts, but we're gonna have our own statement come out that says what we're gonna use, either the final action date or the date of filing. So if you follow the Visa Bulletin and the date of filing shows good for you, you can't go by that if you're filing for adjustment of status. What you need to go is go to uscis.gov, check their decision for that month if they're using the date of filing date or the final action date. If they're using the date of filing, which you're looking at here, I believe you said, then you can file. But if they're not, and typically for employment-based cases, they use the final action date for USCIS. You can't. So whatever the final action date is, that's the number you should look at. And if it passes your date of your priority date, then you can submit it. So that's that. And I have to see your paperwork to give you specific guidance if you can or not. But if you are doing an EB3, you probably have your employer, you should have, your employer has a lawyer. You can always ask him and follow up with them. A lot of times they don't answer because they're too busy, but that's why it's good if you, I'm gonna do a lot of videos of this with a fellow attorney. The importance, it's very important if you are doing an EB2, an EB3 case, even H1B, where your employer hires an attorney and does the work. I know it's expensive, but you really should have your own lawyer, and so protect your interest. Because that lawyer that's working for the company is dealing with a lot of volume of cases, doesn't always pay attention to details of your case, unfortunately. Not every lawyer, but enough where I've seen it be a major problem that most people that do adjustment of status or even consular processing based on an employment-based case where their employer is the one who hires a lawyer and is really handling it, don't know what's going on with their case and are not getting the proper guidance and legal help. And that's why if you do have an adjustment of status case you want to file, at the very least, schedule a couple of consultations with different lawyers. Some do free consultations, some don't. I have a video, either I put it out or it's coming out today, where I talk about the 8 steps of how to choose an immigration lawyer. And one of them is talk to 5 people, have 3 of them be free attorneys with free consultations, 2 paid. Ideally, that would be the situation. And get their opinion in private, because I've seen way too many, particularly Indian citizens who have, H1B, file an I-140, don't know what's going on in their case. There's issues that pop up, and they're not aware of it. And by the time, with that long wait that they have, they come to get the green card, all of a sudden they realize there's this issue that they should have realized they had many years ago, but it wasn't brought up. And so I really want to avoid those kind of stuff. Definitely consult with an attorney. Have your own attorney. That's the best thing to do. Thank you for watching. If you haven't already, please click subscribe down here and ring that bell to get the latest updates. Also, please follow us at the links above on these various social media sites to catch the latest information, live videos, and more to help you be updated on U.S. immigration.